Hi, I'm Henry Quillian here at Taylor English Duma with my colleagues, many of whom are luminaries in the law. This is a continuing series about litigation in Georgia courts, and we will be covering today principally the types of depositions and getting people to the deposition table. We have previously covered other aspects of depositions in previous meetings. One of the things I wanted to bring up as part of a tail on from the previous session was some things relating to production of documents, and we'll cover that as well. I need to give my standard disclaimer to those of you out there in the world that this is not legal advice. This is practical advice that you can apply in your analysis, your own analysis of what you're doing in your lawsuits, but we hope that this training will help. Okay, so the things that were left unspoken about in the last meeting, where we last covered production of documents in response to a request for production of documents, were two things that I thought were important to bring up. One of which is, when you're doing a request for production of documents, I believe it's very helpful to define what documents are. This is particularly true if you are asking for documents from non-parties under 91134, because so many people will think that a document means a piece of paper with writing on it, whereas, as you know, under the Civil Practice Act, the definition of documents is much broader than that, and as we know, 91134 is also for production of things. So one thing I wanted to bring up is having a broad definition of documents that includes modern things such as information stored on personal digital devices, on cell phones, emails, text messages, digital photographs, things that people wouldn't think are a document per se when they read the request for production of documents. As you can well imagine, people receiving requests for production of documents, unless they're wanting to produce something that's very highly valuable to them, are going to try to construe your request as narrowly as possible so it's as little hassle as possible for them. There are so many cases these days that depend so heavily on electronic data and other non-tangible things that you have to include that in your definitions. The other thing is to remember is you can ask for things. For instance, if you got a personal injury case, somebody shot somebody else, Dick Cheney shot his colleague or whatever, then you might ask for the gun, and that would be something to be properly produced. Similarly, if it's a car wreck, you could cause the plaintiff, if you're the defendant, to produce the car for inspection. Now, with respect to production of documents and requesting them, as well as responding, but most importantly with respect to with requesting, these days, if you're talking about electronic documents, you need to know what you're actually asking for, because electronic documents will contain a whole lot more than what the eye might see. Natalie, do you have any comments on what kind of documents could be electronic, or what kind of things you ought to ask for if you're asking for electronic type documents?
Definitely. If you are well, it depends on the lawsuit, but a lot of times people want metadata, especially nowadays, and they ask for native documents, which means that the document, you want the document how it was initially created. So if it was a Microsoft Word document, you want it as a Microsoft Word document. If it was an Excel document, you want it as an Excel document, versus printing it out and then turning it into a PDF, because you want the metadata associated with that particular document.
Well, what is metadata, and give some examples?
Metadata is, once you create a document, and this is a little bit more technical than most attorneys, but nowadays you have to be a little bit more technical. Once you create a document, there's normally a file associated with that document. So like if you create a Word document, it'll tell you the author, it'll tell you the date created, it'll tell you the company, it'll tell you lots of different kinds of information that can be important depending on the case. So let's say that you're dealing with some kind of trade secret or something like that, and saying somebody stole trade secrets. Well, then that metadata might be very important, because it might tell you where it originally created, or who originally created it, what company it came from, and a lot of other information that might be really helpful.
And that would all be something you wouldn't ordinarily see on the screen if you were looking at the document?
Well, if you're, depending on who you're using, you definitely wouldn't get it from just a PDF document that's scanned. So if you have a hard copy document, you scan the hard copy document and you turn it into a PDF, there's no metadata associated with that PDF document. A lot of times people normally will produce document productions in TIFF, and there's actually 3 different ways you can produce a document production. One is TIFF, one is PDF, and one is native. Most people don't want to do native because it's very expensive, and depending on who your client is, you might not want to do it either because you might not want them to have the metadata. But nowadays people are more aware of it. They're more, they realize the necessity of it in different types of lawsuits. They also realize the expense of it. So there are just a lot of different factors that you have to consider when you're looking at document productions and what you want the other side to produce, and be ready to have to produce the same thing. If you want them to produce native documents, then you can't turn around and tell them, I got all mine in TIFF. Good luck, basically.
Now, is metadata searchable?
Yes.
Okay, so if you get this documents in these format, you're going to get a lot more volume, I suppose, than you would if you just asked for some sort of electronic image of the physical embodiment of the document. But you also might find a lot more information from that document.
Correct.
So the basic idea here is you've got to figure out what you need and then ask for it, because if you don't ask for it, there's going to most likely in Georgia courts be a presumption, I think, that at least on the first round of asking, you're asking for a physical embodiment of the document or a printout of the text message or something like that, as opposed to the actual electronic file. But of course, retrieving all that electronic data can be very expensive. Okay, so those are the 2 things I wanted to cover that were sort of a tail-on to our last session. As you know, we try to stop at 1 hour, so sometimes that leaves things either unthought of or unmentioned. The real topic today is getting people to depositions, use of depositions, what type of depositions there are, and the general goal is to make sure that if you're going to invest in a deposition, which is a very big investment these days, that you get your bang for your buck by having all your ducks in a row, having thought through all the technical requirements of taking a deposition in advance. Who has some ideas of what types of depositions there are?
30B6 deposition.
Okay. A 30B6 deposition is a deposition of a what?
Corporate representative.
A corporation, an organization of some kind. Usually some sort of legal entity other than a natural person. What other kind of depositions are there?
Recipient witnesses, fact witnesses.
Okay, fact witnesses, which could either be people that are employed by the parties or people that aren't employed by the party. What other kind of depositions are there?
Custodian of Records, when they come to authenticate documents, which is pretty easy depo. They still happen sometimes.
Okay, so a custodian of records, this may be somebody that has nothing to do with the litigation other than the fact that they are the people who take charge of and are controlling certain documents that contain evidence that are necessary for the litigation. And there's mechanisms for getting all this evidence. The general idea is the rules are set up so that hopefully you can bring the evidence to the court in some manner that it can be obtained during discovery, so that by the time you go to trial, you have what's there necessary to, one, evaluate your case for settlement purposes beforehand, possibly move for summary judgment along the way, and then also eventually try the case. Somebody has failed to, is there any kind of deposition where you don't actually have to go to the deposition?
On written questions?
Deposition on written questions pursuant to what rule? When in doubt?
9/11/31?
9/11/31, yes, and we won't go deeply into that, but basically, if you want to take a cheap deposition, there's a mechanism by which you can send written questions out to the deponent and to the opposing side and ask the person to answer those questions in front of a court reporter. It's different from interrogatories because interrogatories are only to parties, whereas you can take a deposition upon a written question from other people. And who has ever used a deposition upon written questions? I don't see any hands. I don't think I've ever taken one. I may have had one taken upon me one time, upon one of my clients. But basically the problem is, if you don't ask the question exactly like the witness wants to hear it, they can make up some shucking and jiving type answer, and you don't have any ability to do a follow-up question in the same way as you would in normal deposition. Lots of times you don't get what you need out of the deposition. But nevertheless, it is a kind of a deposition. Okay, so let's start with the basics. How would you take the deposition of the president of the opposing party?
Maybe use 36.
No. What if you want to take well, you could get the president, conceivably get the president in response to a 30b6 deposition. But if you just wanted to get Mr. Smith, president of the opposing corporation, how would you get his deposition within the context of a Georgia litigation suit?
Just send a notice with his name.
Send a notice of deposition to whom?
I think you'd have to do a subpoena.
Well, to the opposing party, they have to.
Okay, yeah, so you send it to the opposing party's counsel,
Right.
giving notice to the opposing party that under some rule of the Georgia Civil Practice Act, you're going to be taking the deposition of that person. What rule is that? Not 1130, right? Applies to all depositions. Now, how far in advance of the deposition do you have to send that notice to the opposing counsel in order to get the president to show up for the deposition?
I don't think there's any clear-cut fast rule, but normally you want to give them about 10 days.
10 days is deemed to be sort of reasonable notice. Enough time for the other side to respond. To get it doesn't have to be 10, it could be 20, it could be 5, but a lot of it's going to depend on how much stink the opposing side puts up in trying to avoid the deposition or move it to another time. If you get within 1 week, you're going to be on thin ice going to the court trying to compel the deposition or get sanctions for the non-appearance if the other side has some good reason why they couldn't be there. The president was on vacation, out of town, had some important business meeting in New York or whatever.
Wouldn't your first approach be to work it out with the opposing counsel, like what dates are available for Mr. Smith to come and do a depo?
Aha, a practice point. Yes, although you can force the opposing party's witnesses to show up upon a notice of deposition, Ms. Nicholson points out that it's not a bad idea at all to try to work it out with the opposing party and get agreed upon dates. That facilitates more cooperation by the other side. It somewhat assures that you're actually going to achieve your goal. In many instances, the other side will call you up and ask you, can we take the deposition at my office, my law office, rather than at your office? And you're not necessarily just unilaterally able to notice a deposition of an opposing party at their lawyer's offices, because one of their lawyers doesn't have a conference room available on that day because they're doing something else. So there's a whole lot of benefit of trying to work things out with the other side. What instances might not you want to work them out in advance?
Surprise attack.
Yeah, surprise attack. Sometimes you want to make sure you get the opposing party's witness testifying before they get yours testifying. And so sometimes you end up getting in discussions with the opposing side and you end up having to negotiate out things that you really prefer not to do. So on occasion, you would want to go ahead and notice the deposition without any warning to the other side, try to get it pinned down to get your witnesses in the order that you want them to be deposed. And that's true also of a variety of witnesses on the opposing side. You might want to get the janitor before you get the president because you think the janitor saw the president doing something that the president would otherwise deny he did. But if the president gets deposed first and somehow it gets down to the janitor might be told, you're going to lose your job if you tell me that you saw that, or tell them you saw that. So there's a lot of strategy involved, and also sometimes you just have to think through what's likely going to happen if I do a long series of questions of the senior person first, or the person you think is less honest, and then are there going to be adverse employment consequences or whatever that could cause the testimony of the other person to change. Remember all, we're not dealing with just pure theory. Obviously, a witness can't pretend like they didn't see something legally, but we all know it can happen. So you try to take some of that out of the equation. And believe me, we would never do that at Taylor English. Any witness would be instructed to say exactly what the facts were that they observed or saw in response to a question.
Henry,
Okay.
I'd like to ask a question. In California, the lawyers refer to it as priority and discovery, and sometimes what they'll do in the time allotted after the answer and the discovery period has started, they will notice depots, even though they don't plan on taking them right now, but it gives them priority, and that they have the right to take those deponents before the other side does because they noticed first. Do we do that in Georgia?
That is done by people and argued by lawyers.
Okay.
It is not necessarily accomplished that way.
Okay.
I mean, you can theoretically, if I notice your guy for a week from Monday a week from now, they theoretically can send out a notice noticing all my folks for Friday the Friday before.
Really?
And so there wouldn't be any real
Okay.
basis for me to say, well, you can't have my people on Friday because I noticed your people on Monday.
Okay.
But nevertheless, it's an argument that's certainly made, and people try to say there's some sort of equity involved in the fact that I sent out the paper first. Now, when is the earliest you can notice a deposition of an opposing party? Assuming a normal lawsuit, not any special circumstance.
Federal or state?
In state, we're talking exclusively about Georgia Civil Practice Act and the Uniform Superior Court rule. You can serve the notice of deposition with the complaint, right? And so, and you can set it, I think, the 45th day after the service of the complaint, just like you can cause responses to other discovery on the 45th day after the service of the complaint. Yes, ma'am, Ms. Hyman.
Isn't one of the most useful ways to try to get priority over the other side's deposition to actually serve written discovery before they do, so that you know that you've got yours before they've got theirs, and you usually want to ask your deponent about what's been produced in the written discovery, so kind of want that sequence of events?
Well, as far as getting some answers on the record, you're absolutely right. If you serve your written discovery before they do, they're going to have to respond before you do. If they turn around and serve discovery on you. Now, of course, sometimes the weekends mess that up, and it's possible you end up responding on the same day, or alternatively that their responses will be in the mail to you at the same time. You're going to need to mail yours back, and you don't actually get to see what they have to say prior to answering. But yeah, I believe as a plaintiff, it's very good to ask some discovery that nails down the defendant's positions, and oftentimes they will be totally disproved during the course of litigation, and that makes the defendant look pretty bad if they have to backtrack on every answer they gave in an early discovery. Okay, so certainly there are circumstances that we discussed in several weeks ago or several sessions ago about getting and preserving testimony early on in a case. If you have somebody that's dying, somebody that's about to leave the country, etc. We won't go into that because we covered that pretty heavily before. But in a normal case where you don't have any special facts that you can prove up to establish an earlier deposition, you can serve the notice with the complaint. And I've often done that in fraud cases because you get the defendant at their least knowledgeable time regarding the case, and they'll often come up with every kind of lie in connection with the facts of the case, which usually or very often is disproved by documents that you either get in discovery or that you already have, and you can really make them run around in circles. And then sometimes, on the alternative, you get unbelievably candid responses because nobody's had a chance to coach them regarding all the ins and outs of the case. I had a case where we moved for an immediate, temporary restraining order. That we put the opponent on the stand, and he basically admitted everything, and then he spent the entire rest of the case trying to backtrack from what he had admitted in front of the judge, which made it very difficult for him to say that never happened because he had already testified in front of the judge. He was giving excuses rather than denying things when we caught him on the stand. So, all right. So you've got to think about who you're deposing. Let's assume you sue a California corporation, and and you're in Georgia, and the California corporation has sold a product into Georgia, and you want to depose the president of the corporation in California. Is it a simple question of just merely serving a notice of deposition on the corporation's lawyer in order to get the president to testify in Georgia? Because you sued him in Georgia?
I don't think it's simple.
Why is it not simple?
I think that they could, it's a jurisdictional issue, or the witness only has to travel so far to come to a deposition. And I think that they could state that they don't have to come to Georgia. Maybe if you want to come to California and take his deposition where he lives, it might be easier. I could be wrong, but I don't think it would be just serving a notice of depo.
Okay, there are lots of cases fighting over this, which I guess are pretty factually specific. I believe cases have gone both ways, where the court has held, no, you can't force the corporate officer who, particularly ones that didn't have any involvement in the specific underlying facts, to come all the way across the country to give a deposition just because you sued them, the corporation they work for in Georgia. And then you also might have special circumstances, such as where everything was done in Georgia by that officer and then they moved to California. So the courts definitely can adjust whether you're able to compel by a mere notice of deposition a corporate officer to come to Georgia. Yes, ma'am.
I was going to say, sometimes the best way to handle that is just to remind opposing counsel that it's a lot less expensive usually to have their client come to you and to have everybody, including their counsel, fly cross country, and just practicalities sometimes solve that issue better than the law.
Yeah, depending on who's paying the opposing side's attorney's fees, if it's a closely held company and the guy's gonna have to come out of out of pocket to fly his lawyer around, he may well come to Georgia really quickly. Whereas if it's a huge corporation and the guy just doesn't want to be bothered, they'll probably just tell the lawyers to fight it back as long as they can. See what happens. Okay. If you're trying to get a witness, to depose a witness in Georgia, let's say you're in Cobb County where we are, and you're trying to get them to come to Taylor English, and it's a non-party witness, the case is pending in Cobb County, can I subpoena somebody who is a non-party witness from Valdosta to come to be deposed in Cobb County at Taylor English?
I believe so, but you have to pay for them to come, I think, to Atlanta.
I don't think that even the subpoena works. I think that there's a limit of miles. I ran into this in Georgia, which I thought was kind of different. It's like 35 miles or something, that if they have to drive beyond that nothing short of a subpoena that we get service on them is going to force them to come here, I think.
Okay, actually, we seem to have a debate going on here, so what do we do when we're in doubt?
Check the
Read the
rules.
We rule the rules,
Read the
okay.
rules.
Okay, first of all, we've talked about a non-party witness, and can you just send a notice of deposition to that non-party
No.
witness and tell them to show up?
No.
Well, why not?
You can, they just don't have to show up.
That's good.
Yeah. Yes, you can always send the paper to anybody that has a mailbox.
Right, you can do it.
Okay. What would you have to do in order to get a non-party witness to come under compulsion of the court to any deposition at Taylor English?
Tina.
Subpoena, and what is a subpoena?
An order by the court.
It's an order by the court, and how are they issued?
By the clerk.
Clerk.
So if you were to want to get a subpoena, what would you physically do if you had an already pending lawsuit to go get the subpoena for use to get a witness that's non-party to come to a deposition?
Send a paralegal or a messenger to the court and get one
And what
issued.
does that person have to take with them?
Money.
Money. Everybody wants money, right? Usually they cost a couple of $1
Yeah.
or a couple of dollars each, right?
$5, yeah.
And so the clerk issues a subpoena by signing it and handing it to the courier and brings it back to the office.
You should probably have cash on you because they don't take credit card and
Right.
I don't think they'll take personal check either.
No, they'll only take a law firm check.
Okay, so you got to take money in a form that the clerk will take because it doesn't do any good to argue with a government bureaucrat, right? They'll either do what they have to do or do what they want to do, but they won't do what you want them to do just because you want them to do it.
Right.
If they want cash, they can ask for cash, and I think you're right. They generally do accept firm checks, especially now that some courts are charging for virtually everything you filing motions or whatever. All right, so you get this subpoena, and it's a document, and what does it basically say? It basically says the person who gets served with this document has to lay everything aside and come and appear at this deposition at Taylor English, right?
Well, they use
So-
that word commanded, so that pretty much scares a non-party with you are hereby commanded.
Okay, under whose authority are they commanded?
The court.
Court.
The court.
Okay, so if you send, I guess what you do, I'm just throwing out a hypothetical here, you get the subpoena and you just mail it or email it down to the person in Valdosta?
Nope.
Nope,
Oh, well, what do you do then? How do you get it there?
personal service.
Okay,
Process server or a
Alright.
sheriff.
all right, so you could, let's say you send it from Cobb County law office for a deposition in a Cobb County law office, and you hire a process server and he goes and serves the person down in Valdosta. Must that person show up for a deposition?
Well, first you better make sure the process server is allowed to serve process in that county and jurisdiction.
Well, does a subpoena server have to be allowed to serve process? Do you have to have a special order for delivery of subpoenas?
I don't think so. I think a paralegal could probably drive to Valdosta and serve it. And
Okay,
they just fill out the affidavit.
okay, I think that's right. I think anybody can serve a
Anybody
subpoena,
can serve.
unlike a lawsuit, we talked about that earlier. Only specially appointed people
Right.
that aren't the sheriff or the marshal can serve a subpoena. So,
Can you also waive service of a subpoena? Like if you happen to already be in contact with the non-party's counsel and they're willing to accept service by email?
It has to all be
Well,
in writing. I mean, you
if
can
it-
do it, but you can't enforce it if they don't show up.
if they have a lawyer, if the non-party has a lawyer, they would be, I do think the lawyer can probably accept the subpoena on behalf of his client by whatever means, but only if he has a lawyer. I think if you just email, even if you got an agreement with the witness and just email the subpoena to the witness, I don't think that's gonna stick in court. So you gotta get the subpoena in the person's hands, but is there any other way to do it other than serving them, having a person walk up and hand them the subpoena? Well, you can send certified mail, return receipt requested, right? And you would have to include what with it?
Check.
But would any of this work anyway for somebody in Valdosta? When in doubt,
Check the rules.
read the rules. What rule?
9/11/45.
9/11/45. I think the answer is
No.
possibly.
Oh.
The answer is possibly because there are ways that, generally speaking, the person in Valdosta is too far away to serve them with a subpoena and make them come to Cobb County to give a deposition. However, a person who is to give a deposition, this is 9/11/45B, a person who is to give a deposition may be required to attend an examination in the county wherein he resides in Valdosta. For those of you out of country or whatever, that's a long way from Atlanta and Cobb County. Or is employed or transacts business in person. So if the person transacts business in person in Cobb County, or their business is up here, let's say they have a helicopter, they fly back and forth every day, then you might be able to get them to come to a deposition in Cobb County. Aha, this is a good one. In a county in which he is served with the subpoena while therein.
Ooh.
So what do we have in Cobb County that runs, a big black thing that runs through Cobb County?
I-75?
We have I-75. What's on I-75? Valdosta. So if we were able to tag that person while they're driving to Valdosta on I-75, then we're going to be set. Or if we catch them at
I was hoping to catch him at like the Cobb Galleria or the mall or something,
So-
Cumberland Mall.
So much better rule would be to send free tickets to a concert at the Cobb Galleria Center or at the Cobb Energy Center rather than a subpoena. Have them come to the concert, serve them with the subpoena while in Cobb County, save all that trouble of having to deal with going to Valdosta for a deposition.
Can you lure them here?
You can lure, I believe you can lure a witness, except for to court. We'll go over that. But
Yeah, like if you threw a party and invited them.
Have you ever lured the witness to the Cobb Center?
no, I've never done
LA
that.
tickets much?
But you never know what I might do if I was desperate enough. Okay, we've got a 3, subsection 3 to 91145B. At any place which is not more than 30 miles from the county seat of the county wherein the witness resides, is employed or transacts his business in person.
30 miles.
So, if I want to subpoena somebody from Clayton County to come to Cobb County, and the person resides in Clayton County, can I get him to come to Cobb?
Might be.
Might be cutting it close,
That's close.
Might be cutting it close. And how do you figure that out?
because,
Google Maps.
right, Google Maps.
Okay, yeah, you can use a mechanism to figure out how close you are. There used to be books that had all sorts of tables you could use to figure out approximately how far one place is from another. Is that as the crow flies, or as the car drives, or as the person walks?
I think this is the crow flies, isn't it?
I think it says the crow flies, but it would be quite a debate to have with the court over whether it was 31.1 miles or 29.8 miles, depending on whether it's straight or not straight, etc. So if you have to get somebody from, let's push it down a little bit further and say Henry County, and you want to depose them, you're a lot safer if you subpoena them to a law office in Griffin or something, right? Someplace within 30 miles of the county seat where they reside. So you can avoid, last thing you want to do is do-overs. Whenever you have to get the other side to come to something, you show up, the witness isn't there, you paid the court reporter to come, they're going to charge you a flat fee for just showing up. It's embarrassing to you if you've screwed up and you don't have the witness there due to some fault of your own by not following the rules. So 91145B, carefully read it and make sure that the person you're trying to get to the table actually has to come, because especially if you've just subpoenaed some layperson and you call them up from the deposition room, why aren't you here? And they say, well, I got on the internet and I read the rules, or I watched Quillian's Kernels, and he says I don't have to be here. So that's getting an individual to a deposition. What if you want that person to bring something with them, something they have in their possession that you would like to utilize as evidence in the case? Or at least you'd like to know what it is so you can determine whether you want to utilize it as evidence.
And do a subpoena ducis tecum.
Okay, a subpoena ducis tecum, what is that? Sounds like Latin to me.
Request for production of documents, documents to be produced at the depot.
Okay, so subpoena ducis tecum, I think, is to bring something with you. Is that right, Mr. Hopkins? Okay, so that is not only for authentication of documents, a lot of people seem to equate a subpoena ducus tecum with a custodian of records depositions request for production, but it's basically just a subpoena to make somebody bring something with them to the deposition. What are the limits on things you can cause somebody to bring with them?
Are there limits?
When in doubt,
Read the rule.
all right, I don't know exactly what rule applies, but I think the question is reasonableness. If you ask them to bring their dump truck with them to a deposition, they might well object to that, saying it's going to cost too much fuel or whatever if it's from 30 miles away. If you ask them to bring 50 gold bars or whatever the deposition, they're going to say it's too valuable, it's under risk. They may well seek a protective order, but you can actually ask them to do that. I mean, I've certainly subpoenaed people to post-judgment depositions, which are the same basic rules as far as getting it, but you can have them bring all their jewelry, have them bring all the contents of their safe deposit box, a few of which will no doubt get lost along the way. And so you can certainly cause them to bring things that might contain evidence if they in fact do it. Oftentimes, I would say 50, let's take a poll. What percentage of times when you subpoena somebody that's not a party, just a witness in a case, to bring something to a deposition, do they actually bring what you detailed in unambiguous detail for them to bring that is of a nature that they really have no reason why they shouldn't be able to bring it? What percentage of the time do they actually bring what you ask them to?
You said non-party, right?
Yeah, non-party.
Very little.
5.
So I'm going to say 5 to 50%, which means inevitably you're almost setting yourself up for a motion to compel, right? Or a tongue lashing of the witness who doesn't show up and having to make him come back to another deposition. You had a question?
Well, this is really back on the subpoena ducis tecum. I've seen people issue those, and they say that you have to give them the documents before the deposition. Are they actually allowed to do that?
Are they allowed to ask you to bring them before the deposition?
Well, is there any authority? Do they have any authority?
No, there's no authority for somebody in the ordinance. I mean, there are a few exceptions like medical doctors, I think, and such, but there's no authority to make a non-party witness give you stuff in advance of a deposition so you can review it. But what can you do to help clarify what it is that you actually want the person to bring to a deposition, and to stress to them the importance of actually complying with the subpoena?
Cover letter?
You could do a cover letter with the subpoena. You could
Tell them call.
call them on the phone and without, messing up the testimony they give by trying to fill their minds with too much stuff that the other side's going to get at cross-examination. You can express to them the importance of bringing the things, otherwise they're going to have a motion to compel brought against them in which they might get sanctioned. You can do a lot of things to cause a non-party to actually do what they're supposed to do in response to a subpoena. I've had cases where I had to go from one small municipal entity to another, subpoenaing purchases, documents relating to purchase orders from vendors from each of those municipal entities in an antitrust case. And sometimes other law firms, it was one of these big things where we divide up the work, and sometimes they would say, you show up for the deposition on this day, we'll do the subpoenas, and then you find out that all they did was fax the subpoena to the municipality, and of course that's a complete bust. But so what I started doing, not trusting my colleagues, is calling up in advance, making sure they got what I wanted, make sure things were served right, just so I wouldn't waste the time showing up. So you got to lay your foundation for getting things actually accomplished. Yes?
Can you be liable for attorney's fees or some sort of motion if you somehow make a mistake in trying to get your non-party witness there and then the other attorney shows up can they somehow file a motion against you for their attorney's fees and time and showing up?
Can they file a motion?
Yeah, well, I'm sorry.
I'm just putting it back to you,
Yeah.
Mr. Rosenkranz.
Well, obviously they can, but will they succeed in getting an order for sanctions for showing up in their time when it's?
I think a judge could possibly exercise the discretion to grant sanctions against a lawyer who has set up a failed deposition, because the other lawyer doesn't need to be, and the party doesn't need to be wasting the money associated with showing up multiple times for a single deposition. Now, if the witness doesn't show and everything's been done properly, what should you do if you're the one taking the deposition? To protect yourself from a motion like that, and also to set yourself up for a motion to compel the witness to come.
Make a record.
You'd make a record, which would mean that you would go on the record, even though there's no witness there, right?
Right.
You would present the fact that you noticed the deposition an adequate time before the deposition, the opposing party is present because of that notice. You subpoenaed, it got a subpoena issued for the witness. You'd put proof of the service of the subpoena in the deposition by a copy of the affidavit in which the witness was served, and that the party didn't, it's now 45 minutes after the time for appearance and the witness hasn't appeared. Natalie, is there anything good that can come from doing all that?
Yes, you can win on your motion to compel.
And what can you win?
You win lots of money. No.
You can win it from who?
From the witness, the person who didn't show up.
Yeah, because if a witness who gets served with a subpoena doesn't obey a court order, which is a subpoena, or a subpoena is a court order, what condition is that party in relative to the court when they don't show?
Contempt.
They're in contempt of court. And if you're in contempt of court, the court generally has pretty broad discretion as to how to address the fact that you're in contempt. And we had a case where 2 witnesses didn't show for their depositions, and the court ordered thousands of dollars of sanctions against those witnesses for not showing. Now, part of that was because you can also recover under 91137 the cost of preparing and filing the motion. Now, while we're on that topic, what if you were defending a witness and you file a motion to quash the subpoena that has been served on your client witness? Can you just not show at the deposition?
No.
All right, I see a couple of heads shaking. Why can't you just not show? You filed a motion to quash, that should take care of it.
Yeah,
It's
but
not being granted.
yeah, it needs to be, the court needs to rule on it, either grant it or delay the deposition.
Okay, so there's a case right on point in Georgia, Rice v. Cannon, C-A-N-N-O-N, 641 Southeastern 2nd, 562. Georgia Court of Appeals, 2007. It says that until your motion for a protective order is actually granted, then the court order, which is the subpoena, is not overruled by the subsequent court order, which would be the order on the motion for protective order. So your witness better show up for the deposition, and you better if you don't want the witness to testify, you better object like crazy and have some good reasons why the person doesn't have to testify. Because if they don't show, they can get sanctioned heavily for not showing. Of course, that's heavily dependent on your judge, how offended the judge is, no-show, whether the witness is just a purely innocent third party or whether there's somebody closely associated with the opposing party in the case. Now, what if you're defending a non-party witness who has received a subpoena ducis tecum for a bunch of documents and to appear at a deposition? What can you do?
And that person doesn't show up?
Let's say the person doesn't want to provide all the documents that have been asked of them. Maybe they've been asked for all their net worth documents, and they're just a non-party witness.
Then you're out of luck. You can't get a non-party's net worth. I don't think so.
Well, what do you mean? I'm defending the witness right now first of all, if you subpoena a non-party's net worth documents and they don't do anything, then you can get their net worth document. They may bring them to you, right? Because it's a subpoena, it's an order of the court, it's requiring them to bring it. So you can't say that can't happen, but let's say you're defending that non-party witness. What can you do to prevent from having to produce all those documents at the deposition?
Motion for
File
protective order.
objections.
You can file an objection. When do you have to file an objection?
I think it's that reasonable thing again, but I'm not sure if it's 5 or 10 days. I know you have a period of time.
When in doubt,
Go to the rule.
read the rules. And there's a provision under 911-45A2, which says that within 10 days, let's assume for the moment the deposition is further out than 10 days subsequent to the receipt of the subpoena. Then if you file an objection within 10 days on behalf of that party, non-party witness to the subpoena ducus tecum, that puts the burden back on the party who's seeking to subpoena the records to bring a motion to compel. Now, if your objection is not sustained, what risks are you taking on behalf of your client? So I talked about it earlier. Your client gets subpoenaed, you object. One of the things they've been subpoenaed for is to bring documents. You object, and you object. And the other side brings a motion to compel under 911-37. What can happen?
Contempt of the court's order, and the court will force them to produce the documents.
I think in that instance, since you objected, it wouldn't be contempt, but you may well be sanctioned if you don't have a good reason for not producing the documents. Because 911-37 does apply, and the court in its discretion could decide you just objected just because you wanted to give grief to the party subpoenaing the documents. Yes, ma'am?
Is there any good faith negotiation requirement with a non-party?
Good question. When in doubt,
Read the rules.
read the rules. What would that be? Would that be Uniform Superior Court Rule 6.4? Does anybody else have these, so I don't have to wade through them? Oh, here we go. It would definitely be a discovery dispute that would have to be resolved, right?
Professor, would you repeat the question?
Oh, yes, the question is, do you have to have a good faith conference with the non-party prior to bringing a motion to compel? And I guess in this instance, you're asking, in this instance where an objection has been lodged, a timely lodged to a subpoena. It says prior to the filing any motion seeking resolution of a discovery dispute, it's pretty broad, counsel for the moving party shall confer with counsel for the opposing party in a good faith conference to resolve the matters involved.
But if there's no counsel for the non-party, then that rule wouldn't apply. Because it just said counsel for each side would confer. Amanda wants to know if she can confer with the non-party witness.
Okay, when you have unrepresented parties, what's the general way that's construed if there's rules relating to?
Rules apply.
You mean the mere fact the other side doesn't have a lawyer doesn't mean you can't just run roughshod over
No,
them?
you
You have to treat that non-party or that person that does not have counsel as if they had counsel or as if they are their own counsel, and you have to do everything with them individually that you would have done with their counsel. Right? Same thing with serving a notice of deposition. If you're serving a notice of deposition on a pro se opposing party, you would just serve it on the opposing party because they don't have counsel. So the answer is yes, you'd have to confer. Now, there is that argument that if it would be completely a waste of time and worthless, like if there's an objection actually on the record, that's probably a time when obviously the person is giving some thought to the matter, attempting to address their legal rights. I would say you definitely should have the good faith conference. if a person you served with a subpoena, and the person, when being served with the subpoena, spat on the person serving the subpoena, and called her a blankety blank blank, I never want to see you again, and the person doesn't show up for the deposition, I'm not so sure that you have to have a good faith conference with that witness who's not showing, even if you could ever find that witness again.
What about a situation where you didn't subpoena, a non-party is subpoenaed in a case that you're representing a client in. The person doesn't show and they basically have their spouse call the day of the deposition and say that they're sick. You're pretty certain this is a lie, but is there any recourse at that point?
Just offer to go to their house for the deposition. But I think the answer is unless they file a motion for protective order and get an order quashing the subpoena, then they're at risk. And unless they show up at the court hearing on the motion to compel with a doctor's statement saying they had been to the doctor and they were actually unable to come to the deposition, they're probably going to get sanctioned. So I don't think the spouse called the office defense really works. Might give you some explanation of what happened, but the general answer is, I can understand why they would be sick for doing what they did to you, Mrs. So-and-so. They may show up very quickly.
Henry, I'd like to ask a procedural question. When you serve the subpoena, or the subpoena ducis tecum on the non-party, do you wait to notice the depo? So there's an opposing counsel, you're trying to serve, you get service, then do you notice the depo and attach the subpoena as an exhibit to the depo? That's how we do it in California. So I haven't done any here yet, so I don't know, because you have to give the notice to the other side that there's going to be a depo. You don't want to give him notice until you get service.
Okay,
So-
there's a raging debate that went on only a couple of weeks ago regarding that. First of all, the answer is yes, you always have to serve the subpoena upon the opposing side. When it's a subpoena ducis tecum, you always have to serve the subpoena on the other side with the notice of deposition.
But you wait until you serve it, though,
No,
right?
that's step number one. The step number two is, and this is what part of the debate, maybe y'all can help me fill in, a number of our lawyers believe that you have to serve the other side either at or before the time the witness gets served.
That's what
The problem is, of course, you don't know exactly when that witness is getting served. Like, you can't anticipate that the witness is going to get served at 10 a.m. on a particular day. And so I believe Mickey took the position that you actually have to serve the other side with the subpoena, at least contemporaneously with the witness getting served with the subpoena.
I think you're right.
But
Mickey
one way or
did do
another, you need to do it very timely. If not that, you have to do it very timely after the witness is served. Did y'all read that? I actually read that line of cases that was cited back and forth about 3 or 4 weeks ago. And I don't recall whether any of them specifically addressed Georgia appellate law. Do y'all recall? But I do. Anybody else read those? Okay. But yes, don't wait for sure. And whatever you do, don't fail to let the other side know that you served the subpoena, because that can get you into all sorts of trouble. It's a very good question. Okay, so what is a 30B6 deposition? We've already talked about the fact it's a deposition of an organization, but an organization doesn't know squat, right? It's got to have people that know something that can come be deposed. So what is the purpose of a 30B6 deposition?
To depose somebody with the appropriate knowledge within the company on a given subject.
Yes?
Or given
Most-
subjects, if you put it in the depo notice, because you don't know who they're going to designate to be their 30B6. The more topics you include, it's better to be more overly inclusive than less. So don't just put 5 topics, put 40 topics that you think that witness should be able to talk about.
Whether that corporation should be able to talk about?
Yes, a person authorized on behalf of the corporation to talk about those topics with knowledge.
Okay, does a 30B6 deposition have to cover, does it have to all be addressed by one person at the company?
No.
No, okay. Does the company, if you serve a let's back up a little bit. Okay, you want to get information from a company, but you have no idea who at the company actually has this information. Let's say it's some accounting issue and they're the whole staff of accountants. So what would you do? You would send a notice, and this is an opposing party. You would send a notice of deposition and you would specifically state that it's done pursuant to OCGA 911-30B6, correct? But what else do you have to do in that notice in order to actually get somebody properly teed up at the opposing corporation to come testify?
Describe what it is you want.
Okay, you describe the subject matters, just as Deborah was saying, of the topics, of the information you want. You would say, as one of the topics, deductibility of expenses for so-and-so on this account, something like that.
How about the person having most knowledge regarding?
Well, you certainly ask for the person with the most knowledge regarding. I think you can only force them to produce a person that has knowledge regarding. There is some discretion given to the opposing party to decide who to produce in response to a particular subject matter.
Why wouldn't you have sought the information in interrogatories before serving that notice?
The question is, why wouldn't you have found that information out of interrogatories before serving the notice of deposition? Well, you might have, very well have. Lots of times people in response to interrogatories don't actually give a thorough description of what each person knows. You might have not enough interrogatories to ask the number of questions that you have to ask in order to get the specific individual with the most knowledge of each subject matter. And also you might have some time constraint. Lots of times you can get a deposition faster than you can get responses to interrogatories. And so I guess there might be a lot of reasons, but generally the general course of action is people do some written discovery before they go start taking depositions. All right, so you carefully designate the subject matters upon which you want somebody to testify, and you had a question, Amanda.
Yeah, if you do a 30B6 and the company produces John Smith, and it turns out John Smith is someone who's also a key witness for other things in this case, are you limited at all in the scope of your questions because it was originally the 30B6 deposition that you're taking? Can their counsel kind of carve out what you can talk about, or is everything free game?
They say that you have to go off the record. I read a depo that did that. The guy was testifying as a 30B6. As a result of the 30B6, there was some other testimony that they wanted to elicit. So on the record, the attorney taking the depo said, we're gonna go off as a 30B6 deponent, and I'm gonna ask you questions as a witness. And they literally put that on the record and then went back on after he answered.
Because then they may or may not be answering on behalf of the corporation.
Exactly.
Right, so actually that gets to the point. I'm going to answer that, and Deborah's already answered it to some degree. First of all, a principal reason for a 30B6 deposition is to get the official word from the corporation regarding the subject matters you've listed. You may have all these different witnesses who disagree about this, that, or the other, or they might contend this happened but not that. But you know how it is. You have a big group of people, they're going to see things differently, or they may remember things differently, or they might want to testify differently because they're getting in trouble if they testify the other way. But you will get the official word from the corporation as to what the corporation's position is as a party in the litigation. So that's the other reason, perhaps the principal reason for a 30B6 deposition. To answer Amanda's question, I believe that when you serve a 30B6 notice, you're limited to the subject matters you asked. yes, you can you can make some dealings, like for efficiency purposes, the witness is already here. Why don't we stop this deposition, start an individual deposition of the person if the person is willing to submit themselves to a deposition without having been noticed and without having been subpoenaed. So if I'm defending a 30b-6 and there's 2 subject matters listed and something interesting comes up that the opposing lawyer wants to explore, I'm very likely to say, not going to talk about that here. This witness isn't going to address that. First of all, the witness likely isn't even prepared to talk about that subject matter, might not have ever talked with the lawyer, with the company's lawyer about it. And so, unless there's overriding considerations, if I'm defending the deposition, I'm going to say, stick to the subject matter as you've noticed, and that's it. Question, Deborah, if you're taking a 30b-6 deposition, what should you put in the prologue for the deposition?
Identify that it is a 30b-6 deposition. So many attorneys forget that little tiny detail, and if you're a paralegal and you come into a case late and there's 100 depots and the lawyers tasked me with reading all the 30b-6s, they let me know that maybe there were 10 of them, and if that wasn't in the prologue, I have no way of knowing that it was a 30b-6 deponent. So if an attorney, the minute he goes on the record, says, you know, you are Deborah Nicholson and you are here as a 30b-6 deponent on behalf of Taylor English. And from that, and then the court reporter will even put it on the front of the depot then, a 30b-6 depot. It jumps out at you.
I'll also point out, and that's a great practice tip, oftentimes the court reporter will mess up
Right.
and put just the witness's name on
And
the
not
front of the
the 30.
deposition when it was indeed a 30b-6. Now, obviously, the substance of the deposition will overrule. But if you're trying to get the official position of the corporation, especially if you're the deposing party and you like what you got, you want to make sure that official transcript reflects very clearly that this deposition was the 30b-6 deposition of the corporation. The other thing is, if you only went in going to ask the corporation about these questions, and it happens to be this witness, and your plan is to go depose that same witness on a whole bunch of different subject matters later on, you certainly don't want them coming back and saying, well, he's already been deposed, he can't be deposed again. So, yes, make very clear that it's a 30b-6 deposition, and ask the witness, are you prepared to answer regarding these subject matters? Similarly, if you've subpoenaed documents in connection with, or sought production of documents in connection with the 30b-6 deposition, you know, go over all the documents they were supposed to produce, find out which ones they didn't produce. Always make sure you ask who else at the corporation would know about this subject matter, in case it very well may be possible that you've got one witness who's going to give the party line, and then all the other ones will tell the complete opposite story, which of course makes for good fodder for giving a corporation difficulties in the litigation. Okay, same rules basically for serving a 30b-6 subpoena ducus tecum or subpoena, correct? We are probably about out of time. So thank you very much, and we will see y'all soon. Next month. This did completely run out.